My name is Scott O'Malley. I'm the CEO of ISDA, and I greatly appreciate you taking time out of your busy day to attend this announcement and roll out of this white paper. It's an exciting white paper that we've been working on for some time. And I'd like to thank our partners at Clifford Chance and R3 and the Singapore Academy of Law that contributed to this. As many of you know, as probably longtime ISDA participants and contributors, and we thank you for that, ISDA has spent a lot of time focusing on standardizing operational procedures, legal documentation, definitions. We're up to our ears and eyes with interest rates work right now with the benchmark reform and the initial margin work. So it constantly reminds us that all of this needs constant care and feeding. And when we think about the future and the digital perspective that we have as an organization, we need to continue to advance that cause. So yes, we spend a lot of time thinking immediately about derivatives and formulating different solutions around for benchmarks or definitions, but we also have a long-term view about positioning this organization, positioning documentation, and our operational services for what we think is a very prominent and exciting future around digital services. So when we think about long-term strategies, we think some about the legal, because that is our 35 years on. This is our bread and butter in terms of an organization, and we want to continue to push on those legal frontiers to make sure that we have a clear view and perspective on what's coming and how we need to prepare for that future, including that digital future. So this paper, consistent with our past operational experience in driving for standardization and to make sure that we answer all those fundamental legal questions around new technology, we're contributing this paper to that conversation and using our members here, we're going to kind of unpack the thinking behind the paper, what we wanted to achieve by that paper, and figure out how we make sure that the new technologies like blockchain and cloud services are going to be acceptable and sound places to do business in the future of the derivatives business. So we want to tackle these questions. I know this paper opens up a bunch of questions around the future state and rule of law and some of these other questions around CITES. And when we unveiled this paper a couple of weeks ago in Singapore, you see in that crowded neighborhood with all of those jurisdictions how important those kind of questions are, and people ask those questions. So with these issues that include the introduction of DLT or a platform, we want to make sure that we answer the critically important questions of legal enforceability of netting and collateral arrangements so that they're not undermined by unexpected legal applications of law. Now, our analysis in this paper found that it was unlikely that an English or Singaporean court would disapply or an express choice of law by the contracting parties, whether under ISDA documentation or any other agreement parties choose. The paper also considers the use of digital assets for affecting payments and exchanging collateral on DLT platforms. And here the analysis found that challenges in identifying the precise location of each digital asset, right? These are bits and bytes in the cloud or on distributed ledgers, could result in uncertainty as to which jurisdiction or those laws might apply. Now, the paper sets out some recommendations where such issues might exist, and the parties are permitted to agree to a common law or a law of platform, like a rule book, a uniform choice of law that parties will agree and to govern their transactions on the various DLT platforms. Through this paper, we hope to support these discussions and provide a greater certainty into participants using DLT technologies. And we move a step closer to the operational and cost efficiencies that greater automation will have going forward. Now, I'm going to sit down and join the panel and lead this. I'm going to just field softball questions, and our expert panelists are going to answer these for us. But I'm joined, well, I can't leave the microphone yet. So we're joined by Caroline Dawson, Clifford Chance. She's a partner in Financial Regulatory Group in the London office and specializes in advising financial institutions and other market participants on market regulation. Jason Rozowski, R3, is an assistant general counsel, and he has joined R3 shortly after its launch and helped lead the firm's joint software development projects, including financial institutions for advising technology companies and financial institutions. And we have ISDA's own Karen McGonigal, who is assistant general counsel and runs our legal technology and fintech legal working group. Now, I will make my transition. So to Jason, I think it's important to level set kind of what the paper focuses on in terms of derivative technology and the R3 Corda platform. Can you give us a perspective on how Corda works and how how we should think about these from an operational standpoint.
Sure. So I think the first thing is to understand kind of why Corda was built to begin with, and kind of that falls in line with R3's founding, which was it was started by financial institutions with kind of the aim of going to the market and looking at the different blockchain technologies out there. And the one key kind of point that was missing in most blockchain platforms was the idea of privacy. And so Corda's kind of basic fundamental premise is that the only parties that receive copies of transactions are those parties that are in a transaction. So if 2 or 3 banks are transacting and there are 10 on the platform, only 2 or 3 will receive copies of the data, and the other 7 will not. And kind of everything was kind of built from there moving forward. One of the kind of repercussions of that was there was this kind of bifurcation. So kind of on Bitcoin or traditional blockchain, you kind of have everyone getting a copy of the ledger because everybody needs to validate a transaction. Here you've had kind of a distinction between the users and notaries, which I guess we can kind of talk about a little bit later in this panel as to how you can kind of structure a network in order to take advantage of that for court orders, as we spoke about in the paper. And so I think the other side of this is also that because this was about kind of regulated financial institutions, we have the idea of attaching contracts in legal prose and in natural language to transactions built into the platform, from the ground up. And so the idea was always that you wouldn't only have code that's running and operating transactions, but you'd also have natural language agreements that you can kind of turn to evidence what's the intent of the parties. And I think those are kind of 2 fundamental key points. The last that probably makes sense here is the idea that there's also the idea of regulatory nodes or observer nodes. And so parties or regulators rather that may need to get copies of data that take place on these platforms can get kind of read-only access to only that data that they need to see for purposes of regulatory reporting. And so kind of in this paper what we did is we looked at a lot of these different features and we analyzed a derivatives transaction that we built out using these functions. And then we kind of went from there and kind of tried to answer questions.
Good. I think if you have a copy of the paper and you've reviewed it, I think I was looking for the legal questions, and then when they exposed the kind of how this thing works, I found that quite useful. So I do encourage you to, blockchain and distributed ledger technologies have been banged about in terms of what they are and what they, they're in the front page of the FT for years, it seems, between 2016, 2017, 2018. But it's really important that you understand how they actually work and how the legal ramifications here work. So I think some of the schemas that we've laid out are pretty important. So Caroline, we kind of asked this question: do we have a legal problem? Does distributed ledger cross jurisdictions create uncertainty or legal questions that we can't answer? What have you found? What is the answer to that question?
What's the answer? So yeah, I guess the starting point is that none of these are new questions. Obviously, the OTC derivatives market is a highly international market already. So these are questions that people are already looking at. They're already looking at conflicts of law issues. You already have counterparties in multiple jurisdictions. You already have the potential to be sued in multiple jurisdictions. So I guess the question is, what does the distributed ledger technology add to that? And maybe as a sort of parallel, the question would be, how's it different from futures, I suppose? So if you're executing a derivative contract on a trading platform, how is that any different? Why does that raise any different questions from executing an OTC derivative via the CORDRAP? And I think probably one of those questions, one of those issues would clearly be the fact that the distributed ledger platforms are essentially borderless. So you do introduce, I suppose, more potential governing laws into the mix. So if you're looking at executing an exchange-traded contract on an exchange, fundamentally the contract that you enter into is governed by the rules of that exchange, and that would select the governing law. What we're talking about here is an OTC derivatives contract where you would have selected, so you'd have your ISDA master agreement, you select English law, you select New York law, and then separately you've got execution on a platform, and separately you've got the rules of the platform which govern the interactions between the counterparties, but they don't govern the contract itself. Adding on top of that, then you've got the fact you've got multiple participants, I suppose an issue that you have today, but also the ledger itself doesn't necessarily have a single jurisdiction that you can point to. So unlike an exchange, for example, where LSE is located in the UK, you know who the operator is. For a DLT platform, while you might know who the operator is, the ledger itself is potentially spread across multiple different jurisdictions, and then you've got the jurisdiction of the operator as well. I think on top of that, you've got the fact that the rules govern how you access the system and what you do with counterparties within the system, but they don't govern your actual transaction. They don't override your ISDA master agreement. And then on top of that, you've got the question of collateral. So if you've got a collateralized contract, is your collateral being transferred through the system? And if so, what's the governing law of the collateral? And we can talk about that a little bit more in a minute. I suppose on top of that, then you haven't just got contractual law questions, you've got non-contractual questions as well. So you've got tort, you've got mis rep. So I think clearly there are potential additional governing law issues here. There are potential additional conflicts of law issues, but I think fundamentally it's variations on a theme. I think there are some things which need to be ironed out, but the starting point is it doesn't really raise any fundamentally new issues.
Good, thank you. Now to Kieran, we kind of analyze this from an English Singapore law. Our partners in this have been the Singapore Academy of Law. I think they were curious as to what ramifications it might have on their jurisdiction. So can you kind of unpick what that analysis showed, and do we have a problem in either jurisdiction?
Yeah, thanks. So I think generally speaking, under both English law and Singapore law, as Caroline mentioned, while these are superficially, I suppose, in some respects, new issues, I think these are issues that the industry has dealt with in other contexts. And what the paper found is that really looking at the most common scenarios, the most common contractual frameworks that exist within our industry, I think the introduction of DLT to derivatives trading is unlikely to present many significant issues. And indeed, the paper does attempt to take a really practical approach and look at these issues from the perspective of two of the most common scenarios that you may see in our industry. So looking at the first one, I think this image will seem very familiar to anybody who's any familiarity whatsoever with ISDA documentation. And in this example here, what this is really intending to illustrate is parties entering into an ISDA master agreement, entering into transactions under that ISDA master agreement, and within those transactions, certain obligations, in this instance, payments, are intended to be automated, again, in this example, on the R3 Corda platform. And I think this would be relatively simple and straightforward to implement on Corda in the manner that Jason has suggested. And the other example that we used in the paper is a collateralized transaction. And from a collateral perspective, this would be really very similar to the previous example. You'd have your ISDA master agreement, your transaction confirmations, albeit in this example, you'd have your credit support documentation. And I think what this example is intended to demonstrate are some of the potential benefits of automating things like collateral management, including the automation of collateral transfers. And we'll talk a little bit about this later on in the panel, but I think it's in this example where potential issues arise, particularly around CITES. And I think, again, depending on the nature of the platform and the types of assets that are used, I think in most likely scenarios that we'll face in our industry, this is unlikely to raise significant issues, particularly where settlement doesn't actually take place on the DLT platform or where tokenized assets that represent quote-unquote real-world assets are used. And again, this would be relatively straightforward to implement on Corda. And I think important to say at the outset that none of these examples really raise, I think, significant private international law issues or conflict of law issues. Again, I think we've all alluded to this issue of CITES, and I think there may be some issues that might arise in a scenario where you have a DLT platform that, for example, is designed to host the entire collateral management infrastructure, and where collateral assets are in entirely digitized and dematerialized form. And in that scenario, again, depending on the characteristics of the platform, there may be questions around situs. We'll talk a little bit about that later. But I think important to point out at this stage that really we're not really looking at huge, significant, insurmountable obstacles here.
Okay, let's get into kind of some specifics here. Caroline mentioned netting at the top and making sure that we have line of sight on all of these issues. What are the implications for the enforceability in netting and collateral, and is it impacted at all by the fact that it's on a DLT platform?
Yeah, so I mean, I think these are interesting questions, and so Kieran's mentioned situs and the issues around lex situs. So this is really going to the heart of the analysis around the enforceability of your netting and collateral. So thinking about the location of the assets, and then what property rights you have in relation to those assets, which is clearly pretty fundamental to your collateral. So I think, again, like looking at the normal way that you'd look at this, under English law in particular, you'd apply the prima principle. So you're looking at the place of the relevant intermediary account. So if you're looking at collateral, securities collateral, for example, you'd be looking at the location of the share register for those securities. But as Kieran said, that starts then to raise some questions where actually what you're looking at is native assets on the platform, so completely digital, completely dematerialized assets, which essentially only have an existence on the platform. They don't have a separate share register outside of the platform. And that's when you start to run into these questions of, what's the governing law of those assets? Where are they actually situated? And is the lex situs the relevant law that you should be looking at? And this, again, a few people have looked at this, and there are a couple of options that you could look at for alternatives. I think probably the most popular one at the moment is the location of the the most popular one would be for the counterparties on the platform, essentially to elect which governing law is going to govern the assets. And that obviously has the attractiveness that you'd have a single governing law for the whole of the platform. So you've got, if you're looking at getting opinions, you only have to get those opinions once. You've got some kind of consistency across the whole of the platform. But that's not, that's a proposal that people are putting out there at the moment. I think the FMLC mention it, we mention it in the paper. So it's an attractive solution, but it's not necessarily the answer. Other options would be looking at the location of the operator of the platform. And again, that's maybe not as attractive as having the counterparties select it. The operator could be in all sorts of different jurisdictions. I think also, people have proposed looking at the master key holder for the encryption network. So, I guess if you think about blockchain, you think about any of these crypto assets which are forked, and then something's happened to the key holder and people can no longer access the assets on that fork. These are all sorts of issues that you need to think about if you're then thinking about digital assets as collateral and governed by the governing law of the key holder. And then I think finally the other sort of system that people have proposed is looking at the location of the system participant who's transferring the assets. And there the issue that you run into is that every time there's a transfer of assets on that system, it's going to be a different governing law. So that sort of, it doesn't have the attractiveness of the simplicity of just having everyone on that network choose which governing law is going to prevail.
In a former life, I happened to be a regulator, and when we wanted data, we insisted it to be in the jurisdiction. They're bits and bytes, but we knew who to go call and what door to knock on. Do you think the regulators might have a view on this?
Yes, is the short answer. Obviously in the UK at least, we know that the Bank of England and the FCA are very hot on data at the moment. They're really looking into what kind of data they're getting from firms. I think maybe the awareness of how some of these systems operate at the moment is maybe quite basic. And people are more at the stage of thinking about how they're regulated, whether they are currently covered by existing regulation, whether we need new regulation to address some of these issues. So I think all of this is a bit embryonic, but definitely, if I was a regulator looking at this now, that's clearly something that they should be thinking about.
Yeah. Jason, do you have a perspective? I mean, you guys operate DLT platform. Do customers come to you and say, we want it here or there for either regulatory purposes? Have you run across this question before?
I mean, a lot of the benefit is, our partners are the ones that kind of take our technology and then they build applications for their specific use cases in their specific jurisdictions. So when it comes to the specific platforms, in a lot of ways, they're kind of answering their own questions. They're just using our kind of technology to facilitate the transactions. I think what's interesting is, there is this kind of contractual hierarchy that's kind of developing, right? Because if you break down these transactions and you have, the value, which is the token, you have the contract between the counterparties, then you have the contract for that platform. Just on those three levels, right, there's a lot of issues to consider in terms of, again, kind of where's the asset sitting, where's the data that represents the asset, the obligation between the counterparties. And I think the important thing to consider is also, as this kind of develops, there's also the inter-platform considerations, right? So if you want to take the dollar from one application, be it insurance or derivatives or whatnot, and move it to a trade finance application, at that point of transfer, there's also kind of obviously issues to consider in that realm as well. And so we're kind of working on hopefully playing a role in somehow kind of creating a framework for that inter-platform transfer once kind of folks on the kind of specific platforms start to answer some of these questions.
You guys have a partnership with HQLA.
Yep.
Does that have any relationship to some of these questions in terms of that collateral sharing? That seems to be a pool of collateral and people kind of debit and credit off of that pool. Does that have anything we can learn from?
Yeah, I mean, so I think I know a bit about HQLAX. So that's a, I think they're is it Belgium? Yeah. So what's interesting there is the ledger of record is actually the one that's held by HQLAX, right? And so I guess from regulatory considerations, if there's ever a question as to who actually owns the high quality liquid asset, they go to HQLAX. And so, the tokens or the I guess the assets that are being transferred are actually just representations of what's on the HQLAX ledger. So that was kind of their way of, I guess, solving for their regulatory considerations while still kind of trying to take the benefits of blockchain.
Does it? And I'll open this up to anybody. Does this paper and on the question of, I think the first one you identified, Caroline, parties can elect. Do you see that as probably being the most adopted solution here in terms of how people want to solve for some of these things? I mean, you listed 4 of them, and many of them are, you take a risk, where the platform is or some other jurisdiction. Do you think people would do the election between parties, or maybe the platform will say, all right, we're just going to decide under English law for these purposes, and everybody has to agree to it like a rule book?
Yeah, so I think from a regulatory point of view, I think that approach makes sense. It's if you have a rule book and then there is a single governing law for all of the transactions on that system, I think that does make a lot of sense. Like I say, it creates efficiencies in terms of opinions. It means that, for example, if you're looking at litigation, so things being tested in court, if it's English law or New York law that's the governing law of the system, or Belgian law, for example, then these are court systems which have sophisticated judges. There's a good track record, and then you can build on that track record, and it just helps build that certainty. But I suppose in terms of what happens in practice, I don't know if you've got visibility over that.
I mean, I think a lot of these rule books are kind of just coming into the picture right now. I was actually speaking to someone about that just before this, but yeah, so I think it's just developing. But yeah, I think as a general matter, it's most folks want certainty, right? Yeah.
Now, we obviously took Singapore and the UK in terms of jurisdictions that we're thinking about. What happens when the inner tubes or the vast World Wide Web goes across Vietnam or something like that, where they don't have netting, they don't have some of these other things? Does somebody have a claim on that? I mean, what do we do in these other jurisdictions where no doubt blockchains are going to be popping up?
Yeah, so I guess you probably come back to where we started, which is the question of whether the DLT platform actually impacts the original problem that you had. And so that's where we started. I guess the second question is whether it improves the situation.
Yep.
So if you're talking about counterparties in Vietnam, where, as you say, there isn't netting at the moment, you can't get a clean netting opinion, that's kind of, for, if you're talking about executing master agreements on a DLT platform, that's probably where your problem is, rather than the DLT system itself. And I wouldn't have thought that the DLT platform is going to add that much, really, in terms of problems to that. And then the question would be whether actually you could help fix some of those problems. So if the DLT platform was governed by English law, would that change the netting analysis? I mean, that's, probably something for another day.
I do want to open it up. If any of you have much deeper, more thoughtful questions than I've come up with, I'd certainly, want you to ask those questions of our panelists. Certainly, if you happen to run a DLT platform and have come across these, we'd certainly love to have your thoughts as well.
Could I just make a point on, I think, disputes more generally as well? I think, again, just important to emphasize when we're talking about questions of CITES and law of the platform, we are talking about, I think, a fairly narrow fact pattern. But I think it's important to note generally, in terms of contractual disputes, what the paper emphasizes is that parties' choice of law will continue to be respected in the same way that it is today. So the introduction of DLT into traditional trading relationships doesn't necessarily need to impact upon the way in which contractual disputes are resolved. And in fact, actually, there are probably slightly novel ways in which a DLT platform like Corda, for example, could actually help with the enforcement of disputes. So, the notary function on Corda, for example, is something we talk about in the paper that could be potentially very, very valuable in some of these scenarios.
Yeah, and I think, a point from before is that, at least on Corda, right, there's also a permissioning aspect, right? And so you have to go through this function, it's called like a doorman. But the idea is you have to, have permission to be on the platform. So, if issues and jurisdictions may pop up, you'll know about who you're dealing with beforehand. Yeah.
What about international law conventions? How can they either help, evolve maybe, to address the new brave world of digital assets and platforms? What needs to happen on that?
So, I suppose one of the things that I've seen certainly is that there are various jurisdictions around the world that are all moving at different pace. So there are jurisdictions that, for example, are trying to attract some of this activity to their jurisdictions and have introduced fairly liberal rules and laws around this stuff. Other jurisdictions are more cautious. I think international standard setting bodies have a really important role to play here because it's important that this is all consistent, whatever we do, to the extent possible. We're talking about cross-border activity. We need everybody to be, generally speaking, playing by the same rules.
Yeah, I guess was the question about international standards, or was it more along the lines of Hague Convention, Lugano?
Both, actually.
Yeah.
What can Hague do, or Rome?
Yeah, so I guess I don't have much to add to what Kieran said on the standard setting side of things, that clearly that would be helpful. I suppose in terms of Hague Convention, Lugano Convention, it probably, again, comes back to the point that, these are going to be helpful in the same situations that they're helpful today. So if you've got questions about, governing law or jurisdiction, then these are questions which people already have today, and people know what the analysis is in relation to Hague Convention, Lugano Convention. Potentially we're adding different jurisdictions if we're starting to look at the jurisdiction of the collateral transferring party, or if you're starting to look at the jurisdiction of the operator of a particular system, then we might start to look at jurisdictions which are outside the scope of some of those conventions. And then clearly it would be helpful if more jurisdictions were added. I suppose in terms of whether you could have, let's call it a London Convention, a Singapore Convention, which exclusively governed enforceability of contracts executed by DLT, I'm not sure that actually that would add much beyond the existing body of contract law and private international law that governs those conflicts.
So we kind of shouldn't overthink this, right?
I think that's right, yes.
Yeah. ISDA's onto a bunch of other things as well, and we've done some other analysis, which I'm going to ask Kieran to get into, but some of the work around smart contracts is pretty interesting to us, and we think about making sure that the code delivers on the legal contract and the legal terms. And as we think about some of the smart contract terms and conditions, we want to make sure that it delivers as expected. So, Kieran, can you kind of walk us through what else ISDA's been up to in this area, and then maybe pose the question to you and Caroline: will we need code opinions? Will we need lawyers to provide different jurisdiction opinions that the code delivers on the contract? So you can ponder that question while Kieran goes through these other efforts.
Yeah. Thank you. So I guess the big question is why are we doing this? What are the benefits of smart contracts or smart derivatives contracts? And on this slide, we see some of the benefits that we see. So increased accuracy and transparency of contractual terms, efficiencies that can be gained through automating performance, and less scope for misinterpretations or competing interpretations of contractual terms due to greater alignment between the contracts, between the process that is designed to implement those contractual terms and the data that sort of is consumed and flows from that. I think important to note at this point, we've been talking about DLT a lot, but we take a technology agnostic view. We're not promoting a particular type of technology or platform. And when we talk about smart derivatives contracts, I think really what we're talking about is the automation of certain aspects of the contract. That may require certain aspects of the contract to be written in code or some other formal representation. It may not. It may involve DLT, blockchain, smart contracts, cloud, AI, or some other technology. But from a legal perspective, really what we're looking at and what we're focused on, as I said, is the automation. And I think there's a really important first question that we've been asking ourselves and grappling with, and really all of our work has circled around this, and that is how much of a derivatives contract can you actually automate? And there's two aspects to that. Is the automation effective? So, to Scott's point, can you take a natural language contract provision, represent it in code, and be certain that the performance of that contractual obligation will remain the same, or that it will remain as intended by the contractual parties? And then secondly, is the automation actually efficient? So if you assume for a second that you can automate everything in a contract, it may not be efficient to do so. The benefit or the cost may outweigh the benefits. Those are two important things to consider. Very quickly, just run you through our thinking across both of those. So when we talk about effective automation, our view is that it's much more, automation is much more likely to be effective when it's applied to contractual provisions which are primarily operational in nature. So things like deliveries and payments, things like, you recall the collateral management slide that I presented earlier, collateral valuations, things like that, they're very operational in nature. Things which are non-operational, which require human intervention, judgment, expressions of time, all of that kind of thing, conditional or non-conditional logic, those are much more difficult to automate. So we would suggest that thinking about automation, it's much more likely to happen at the transactional level, where economic terms, payment mechanics, and things like that are contained, versus, for example, determining whether a bankruptcy or other event of default has occurred. And just on that point again, talking about efficient automation, even if it were possible to automate some of these terms, it may not be efficient. Consider, for example, how difficult it would be to automate the occurrence of an event of default, like a bankruptcy, all of the various different steps and technologies that you would need to implement in order to do that. Would you ever really want to take manual or human intervention or human discretion out of that equation? I'd suggest not. So it probably, certain provisions, even if they were effective to automate, possible to automate, it may not be efficient to do so. And again, that really focuses on complexity within the contract. And within contracts, it's contractual terms, they don't exist in a vacuum. You can't just look at a sentence in a contract and think, oh, I'll go away and automate this and everything will be fine. There's other things within the contracts, and particularly in the ISDA documentation architecture, you have different documents within that, all of which may impact upon, take a payment, for example, the quantum of a payment, if a tax is levied, whether a payment is actually due, if an event of default has occurred and parties are relying on Section 2A3, who a payment is actually due to, if there's been a merger or acquisition. So there's lots of stuff within the contract that you need to consider, a lot of complexity when making that determination. And just on the things that we'll be discussing today, complexity beyond the contract. So these are the broader legal and regulatory issues and questions that need to be answered. So things like, is a smart contract legally enforceable? Are electronic signatures enforceable? How would a court interpret contractual provisions that are written in code versus natural language? And questions around situs that we've discussed. And we are tackling a lot of these issues through white papers such as the one we've published, various legal guidelines documents which look at some of these issues from a specific product and process perspective. Our contributions to studies like the UKJT, the UK Jurisdiction Task Force legal statement last year, which opined on some of these issues from an English law perspective. Scott mentioned work with international standard setting bodies and regulators will become increasingly important as we move through this. And also the publication of e-contract opinions, which look at the enforceability of electronically executed and confirmed contracts. They're obviously really important as we move into a more digital DLT-like environment where, if we're moving away from paper, it doesn't make sense to continue with wet ink signatures. So ISDA have published a range of e-contract opinions for various jurisdictions on that as well. So how do we get there? So ISDA's strategy, standardize, digitize, distribute. So our view is that you'll never really get to a place where you're able to automate contracts on a large scale unless those contracts already benefit from a high degree of standardization. So we have done a lot of work, for example, in the ISDA Clause Library project, the work that we're doing on our 2020 definitions to increase the levels of standardization that we see in the underlying documents. That will then allow us to digitize those contracts through the ISDA Common Domain model, which, for those of you who aren't aware, is a project, again, run by ISDA, managed by ISDA, which intends to create a single digital representation of derivatives lifecycle events. I think it's really important that as we move through that process, the digital components, the digital processes are closely aligned with the contractual obligations because they're, the one derives from the other. Me with my lawyer's hat on obviously thinks that the contracts are at the center of everything. The idea being then is, as we move through this process, you have standardized contractual components which you can then digitize. We can publish them and then they can be implemented across technology solutions in the market aimed at improving, increasing automation in the market, and people will have confidence that that all links back to the underlying legal obligations. It's all consistent and it all works. I'll just leave that up there. This was a summary of the work that we've done, the various papers that we've published, including this one, the website link that you can access all those papers from, and of course a plug for the working group. If you're interested in these issues, do join the working group.
Thank you, Kieran. Yeah, go ahead.
Apologies if you said this somewhere else. You said that ISDA is technology agnostic. You obviously own the copyright to the documents that you produce, including the master agreements and the definitions. Is it your position that a third-party software provider can use those without essentially you're giving them a license to implement that language? Or what exactly is, because at the moment, I don't work for a software provider, I work for a bank, but it does seem a little bit like the way these projects are being rolled out is you partnering with a specific software provider in circumstances where there are an awful lot of people out there with the skills and technologies that could build something useful for the market, and it seems to be a choice of either the people you've chosen or building it in-house and then going on to the general ISDA license that all participants have to essentially do the documents there. It seems slightly limiting to me.
Yeah, I'm very conscious that our general counsel is sitting in the front row shaking her head vigorously.
Thank you.
We have a licensing program where much of our intellectual property we freely license at low rates. Sometimes our board makes the decision to embark with a particular partner on a particular project. So an example of that is on ISDA Create. We do freely license all of those documents that are on ISDA Create to other providers. So we're certainly, although we do sometimes partner for the broader objectives, we still do freely license, sometimes for a nominal fee, but often, a very small fee, most of our intellectual property. And, on some of the on the CDMs, could comment on the decision the board came and how we make some of those other elements available.
Yeah, on intellectual property, there's a number of factors. One, if you do use our intellectual property, we will hunt you down. And we know which court of law that will protect that. The other one is we are we are very open to making sure that all of this finds new and creative ways, and a lot of people have approached us with different collaborations, which we're always happy to work on, and to evolve the documentation and the services and the IP as well. So the common domain model is open source, and we're looking at different governance models to make sure that we move at the pace of software and agile working, where you fork code and you amend it and you bring it back. So we want to make sure we drive industry standards and we support that, and people aren't misrepresenting what that is, because we obviously have a broad membership that we can collaborate to add to it, and we think that makes the code better. So we could protect the intellectual property and still have an open source so everybody can contribute to it. What we want to do is make sure we have version control so the quality remains high and the standards are consistent. So when you're using CDM 2.0, it's the latest and greatest. When we evolve it to 3.0 and somebody's representing it as the latest and greatest, it better be 3.0. So we want to make sure that we do have some standards around that to make sure that all of the work is being supported. I think this is a brave area for us in terms of how we think about it, but there's a lot of effort that has gone into the thinking thus far and evolving our partnerships on this. Go ahead. You want to follow up?
Okay, slightly provocative question. If you're working on a project and somebody has a better way of doing your project and they come to you with a licensing request, you're saying that you're not going to be protectionist about your project and you will license it on reasonable terms?
We're more, Catherine may want to answer this, but we're more protective of the IP that's gone into it, less precious about the product and the project itself. There are plenty of people representing CSAs out there that are, that they've kind of used for different applications, and we've given them a call and said, hey, by the way, this has got some protections around it. So we'll just, it's case by case, But we are pretty, I think, thoughtful about it.
It's more, as Scott says, on the ensuring that it's represented as published. If, for example, someone wanted to take our intellectual property and add to it, we have those arrangements where, we've licensed other trade associations for development of local documentation where we say, hey, this is the ISDA published version. You can add your country-specific provisions, but just don't look to us as ISDA to validate that that's accurate. So that's one specific example.
There's one way in the back, Peter.
Hi, I noted that the paper is exclusively from common law perspective, and I would like to ask a question on how would you explain to civil law legal practitioners representing more than 60% of the world population, including China and the EU, that enforcement of a smart contract should be recognized in their jurisdiction and the choice of English law recognized when the smart contracts are not actually recognized as contracts in their jurisdiction, therefore not subject to Rome I regulation, Rome Convention, and actually the civil law jurisdiction referred to smart contracts as IT protocols or computer programs that can facilitate automation of performance of contractual obligations. And they are focusing more on regulating DLT technologies, and they are likely to touch on mandatory law, focusing to explain ability of IT protocols, considering that it might have high risk when this is distributed to a large scale. Thank you.
Sounds like a topic for a second paper.
Yeah, I mean, it was, I suppose, impossible for this paper to be completely exhaustive and cover, multiple legal jurisdictions. I mean, I think that to the extent that there are local law questions around, for example, the enforceability of a smart contract, it may be that that jurisdiction goes through a similar process to that recently done in the UK, through the UK Jurisdiction Task Force, and answers those questions. That may happen in the future. I'm not aware of that. You're shaking your head. But yeah, I mean, it's possible that that might be an area of further study for us.
Yeah, and I mean, I suppose if your question was also going to how would you present this to civil law regulators and legislators to sort of, you know, to encourage them to move in a similar direction, then I think, again, clearly, you know, there's space for lobbying on this point, and maybe lobbying is a slightly unattractive word, but, you know, that there is space, as Kieran says, for a further paper and, you know, for explaining this. But also, I suppose, explaining the consequences of not clarifying some of these points. Which is, you know, if you can't get comfortable that what you've executed is actually a valid contract, which is then going to be admissible in a court of law, in the court of law that you've chosen, you're not going to execute that contract. And, you know, that's something that some of these jurisdictions might want to think about, or maybe this just isn't something they want to touch with a barge pole. You think the latter?
Yeah. No.
Yeah.
The thing is that is 60% of jurisdictions are civil law jurisdictions, and they tend not to consider that as contracts.
Mm.
So there is an additional complexity to the issue, because, you know, the assumption started is that it doesn't add to the problems that already exist, and the point is it actually adds, because we are not discussing contracts, we are discussing something else.
Yes. Yeah, and sorry, for anyone who couldn't hear, the comment was just to repeat that 60% of the relevant jurisdictions are civil law jurisdictions, and that smart contracts aren't recognised as contracts in those jurisdictions. So if our starting assumption was that, you know, you've basically got these problems today and that the DLT platform doesn't add to them, that's not true for those jurisdictions. I suppose, just in my defence, the starting point was also that we were talking about English and Singaporean law, where these are recognised as contracts.
And I think, if I can add that, I think these absolute numbers don't really fully represent the real situation, because even in what jurisdictions, there's a lot of diversity with regard to the characterization of these contracts. So I wouldn't necessarily go for a numbers game, and more diligently focus on the need that each legal tradition and each legal system needs to find a way to address this problem in an appropriate way to make its local system up to speed, really. That's one of the exercises one could think about going forward as a consequence of this paper. But were there other questions? Yes.
So,
Sorry.
just a quick note. So, and I think, you know, this has been addressed in other ISDA papers, is kind of, you know, what's the distinction between smart contract and smart legal contracts, right? And so, you know, definitionally, right, smart contracts, you know, just being code that's kind of executed because there's an input and then it leads to an output. Maybe that's one way to say, all right, you know, that's not a contract, but you know, I think there's different factors, especially in all the papers that have kind of come out to date, about the distinction between just the code, but when that code is actually representative of an actual contractual obligation, and also, you know, kind of the analogies you can draw as, you know, this paper goes into the fact that there's an actual natural language agreement that's tied to this transaction, right? You probably still have to answer the same questions around electronic signatures, right? Those are the same ones that exist today. You still have to answer questions about electronic documentation. Those are the ones that, you know, same ones that exist today. But I think a lot of, you know, the points around the papers that have come out to date is that, you know, that distinction between smart contracts, smart legal contracts is probably, you know, key to focus on, and then you could kind of start drawing analogies that maybe make these questions a little easier to answer.
We had one question.
Question over here?
Hi.
If a state was to create...
Can't hear you.
Sorry. If a state was to create a central bank digital currency, and if that was to be used as a pure asset in a collateralized derivatives context, would the jurisdiction of that digital currency become relevant?
Depends on if it's civil law or not.
I think the short answer is yes, but I suspect, I mean, it's partly going to depend on how that digital currency is put together, how it's constructed. But I would imagine that if it's a central bank digital currency, there's going to be some kind of register somewhere to track ownership. And then you're going to come back to the Lex Citus, and you're going to be looking at the jurisdiction of the register.
There's another one up here.
Oh, sorry. I was wondering.
People in the background here.
Thank you. So I was wondering if the DLT can add or improve risk management and can change or impact capital requirements in any way.
I think that's for technology and.
Yeah, I mean, so I think, what the big benefits, right, is that you're able to kind of have all the data, all the holdings that everyone has at one time, right? You can get a snapshot, right? So you don't have to kind of unwind transactions. You don't have to kind of look to, what contracts are in place. You could get that reporting function that we kind of described or we kind of talked about at the top of this, right? And so, what implications those kind of have towards, the considerations for why you have these requirements in the first place. Maybe someone can answer that better than I can, but the reality is that, you're able to get a lot more data, a lot more accurately at that point in time. And so, maybe certain requirements could be eased, if that makes sense.
I think a lot of when we approach this question around how do we improve standards, how do we improve operational efficiency, we obviously have a number of partners, that infrastructure providers, whether they're clearing houses or different infrastructures, that are doing fantastic work, that have already done work to keep the system working as it is. But we have new requirements due to regulation. Obviously, technology has evolved to a position now where you have different capacity around DLT. And one of the things that we think we can do most effectively is help drive those standards to put, the common domain model is one of those, so we can bring more operational automation or to scale to solve some of these problems. We do see a bilateral market that has been plagued by data inconsistencies, the way people hold data and manage data, and then when they kind of reconcile it, it's a dog's breakfast, and it's just a mess. And we see breakages, we see human error in inputs, we see unreconcilable data fields, and the whole process just takes much longer than it needs to. So that's a risk in and of itself. We believe by setting those life cycle events in a consistent framework, then you can bring more automated solutions. People will be able to take either steps out of the process, which would save time, energy, and money, and get probably faster reconciliation for many of these things. That's just the tip of the iceberg in terms of what the potential is here, but we think that's probably where we can add the most value in terms of increased efficiency and automation here.
And I think to Scott's point about CCPs, they started off as private facilities for risk management, and now we've got to a point where you've got mandatory clearing. So, maybe in 20 years' time, we're going to be looking at mandatory execution on DLT, possibly not in civil law jurisdictions.
Even in 20 years, that can. Any other questions? Fantastic. Well, thank you all very much for coming. Thank you. Join me in thanking our panelists for their contribution as well. Thank you.